Hello, friends. Welcome to the fourth edition of Lifft India Filmotsav and Awards World Cinefest 2020. As we know, Lift stands for Literature, Illusion, Film, Frame, TV, and Theatre. It covers all the allied arts, and we always refer to the concerning issues pertaining to all these fields. So here we have today with us Ms.Anamika Jha. She is an attorney for media and entertainment, and she's a legal advisor for the screenwriters' legal issues. Hello, Mr. Namika Jha. A very good morning to you.
Very good morning, Mr. Bajaj.
Hi.
Hello.
I'm delighted that you accepted our offer to come on this conversation session with us for Lifft India and throwing some light on the issues pertaining to the legal issues faced by the screenwriters, especially, and the points that are to be spread for awareness, which can help all the writers and the creative people for screenwriting in the especially Bollywood or what we say in the film writers in India. Uh, so I would like to begin with what is your role as a legal advisor to the writers? I mean, because this is something which is very diverse and complicated. That how do you help the writers as a legal advisor?
Yeah. So, first of all, pleasure is all mine to be here at this platform and so that I can talk about the various issues. And I am always passionate about it, like when it comes to about the legality and rights. And my role as a legal advisor, so I am in the transaction side of the law, means mostly about the contractual. So when you talk about any legal issues, it has two phase. First is the transaction part, where you need to be very solid at your document, when you need to be very solid at your negotiation, and then coming to a proper agreement. And another part is being the like litigation side, when you have no option but to go to the court. And generally, this happens due to the bad document or not proper homework which you do at the time of transaction. So I generally help writers, sometimes other like creative people, like including directors, small time film producers, and everyone, so that they can understand that in the beginning they have to come up with a proper agreement, in which generally there is, when you talk about the writer as well as a producer, there's huge bargaining power. One side there is a big corporate house, the other side there is an individual. So when you see the agreement, there are very one sided terms and conditions, and generally you can say those contractual exploitation, like the means, those documents become the means to contractually exploit writers. So my role comes here to guide them, so that whatever they sign should be a proper document, and whatever, like how to pitch their work so that they can get the maximum protection. And then comes to the negotiation parts also sometime. And then you cannot avoid the dispute. So when dispute happens, how to go further. This is one part of my job. Another part, when copyright infringement happens, suppose when someone has copied your work, then what to do? Like, you have done your best to protect your work, but then also there comes the way when your work get exploited or people infringe your right, then what to do? My job comes there too. I also advise Screenwriter Association as their legal advisor. So all these, the entire domain of their legal work, I do there. So yeah, as you rightly put, it is a vast and at the same time very satisfying too.
What made you choose the field for screenwriters, especially, or the media and entertainment as your area for the attorneyship? Because generally people go for the other areas and fields, which is more corporate.
Yeah. So I was always, when I was in my law school, I was very passionate about media and entertainment due to the copyright. Copyright was one of the very, like one of the favorite subject for me due to its organic nature. Because you see, every day creativity is evolving. And the way creativity evolves, the law also has to evolve. tomorrow, yesterday we do not know, like 3 4 years back, or you can say 5 years back, we did not know anything about OTT, and now OTT is a norm. Similarly, the law also changes the way art evolves, and I am being a person who like you can say a bigger movie fan from the very beginning of my when I started watching films and all. And then the law, how it governs the all aspect of films and movies, so these inculcated my interest. And then I got opportunity here at SWA to serve as their legal advisor to get the practical exposure, and I landed here. So yeah, so this is
Uh,
how
uh,
it built.
that's interesting. So, what is the difference between SWA and a copyright office? Could you throw some light on that?
Yeah, so it is a very common question. I like people ask me, but those things are like copyright office as well as SWA. Both are entirely different things. Copyright office is a statutory body which government has established in order to register your work and in order to function how the copyright should be function in the country. While a screenwriter association is a body of writers which has been formed to protect the rights of the writer. Now the other questions come that whether register what is difference between registering with copyright office and with the screenwriter association. So there is a difference. In a screenwriter association, when you register your work, it is the proof of your authorship. See, copyright does not require a mandatory registration, but registration gives you an add-on. So when you register your work with the Screenwriter Association, this means that you have the proof of authorship. Whenever you send your work to the production house, the people come to know that yes, you are the author of this work and you have registered it, created a formal record of it. But when you register a work with Copyright Office, then it is the proof of both authorship as well as a ownership. When a producer who has get the assignment of a script in his or her favor, then even the producer can go and register the work in the Copyright Office as an owner of the work by producing the proof of ownership. So these both are entirely different, working in different domain.
So that just sparks a question here. Uh, that what is like you said, a producer can also walk into the copyright office and register the work. So, can the producer register the work which is written by a writer, or he has to register it only if he is the creator or the writer of that work at the
Okay.
copyright office?
Okay. So producer will be always see one there is one confusion among the people regarding the authorship and ownership. Okay. So when you write a work, you are the author of the work as well as you are the first owner of the work. Okay. Now, authorship is something which you cannot impart. If Anamika has written something, then Mr. Bajaj cannot be the author of that work. Even if I get the money from you, even then I cannot make you the author of that work. But what I can make you is the owner of that work. So what I can do in India, it is a transferable right. So copyright is a transferable right. So I get money from you and I assign
Okay.
the entire rights in your favor. When I assign the rights in your favor,
Yes.
then I don't remain the owner of that work. I just remain merely the author of the work and you become the owner of the work. So once you become the owner of the work as a
Okay.
production company or as a producer, you can go to the copyright board and register your work as the owner of the work. But Anamika will still remain the author of the work. So only the natural person can become the author of a work. A company cannot become the author of the work. Company can only become the owner of the work if there is a proper written agreement through which the assignment has been done. So this is how this goes.
So that means that in the absence of a contract, the author continues to be the owner of his own work.
Absolutely. And again, there is so many confusion in this regarding this question too. And I'm glad that you asked this question. So what happens? What my experience as a legal advisor to screenwriters, I have seen that in many situations, producer approaches the author, and producer says that, look, I have this very fantastic idea. Just make a suppose I have an idea about people on earth falls in love with the people in Mars, some alien love story. So you go and develop it. They don't sign an agreement. Producer just pays some amount like 10 to 15 or 50,000, whatever, to the writer. Now writer starts working. There's no agreement between the producer and writer. Okay. If there is
Yeah.
no agreement between producer and writer, then there is no assignment of the work. Okay. So in that case, only merely just making some payment, a person cannot become the owner. You have to have a written agreement. Section 19 of Indian Copyright Act is very clear about that. That you need to have a written agreement in which you need to describe all the rights that has been transferred, and then only you will become the owner of the work. Just making some payment cannot make you the owner of the work, and author remains the owner of the work. So when now people say that this was a commissioned
Uh,
work.
yeah.
So even for commission work, you need to like produce the evidence, and contract is the evidence. You need to have a commissioned work agreement with the writer so that you can prove that, okay, I have commissioned this entire project. This is the agreement, and in that agreement, you have to mention that under section 17B of the Indian copyright, I am the owner. So these things is required to be proven. Then only you can call yourself the owner. And all in all other case, without any exception, author remains the owner of the work.
So is writing for plays, novels, storybooks also copyrighted? Do the writers of these works need to first copyright their work before handing it over, either for publication or self-publication or the digital publication, which is very popular these days? If yes, then how and where? And what are the pitfalls that the writers face, especially for the novels and the plays, or the story writers? Which are
Okay.
publishing.
Yeah. So see, you need to understand what elements copyright protects. So copyright protects all the artistic work, whether painting or anything artistic which may. Then literary work. Okay. Literary work, your book, novel, story, everything comes under the literary work. Then dramatic work. So screenplay or the drama, the script for drama, all these things comes under dramatic work. And then there is the musical work, then there is sound recording, then there's cinematographic work. All these works are protected under copyright. So yes, the author of the novel, author of the drama, author of all these genre are gets protection under Copyright Act. And all these work are copyrighted work. Now, registration of a work, copyright work is not mandatory under our law. Even if you have created, suppose I write a blog,
Yeah.
so whatever I write, that is a literary work, okay? And I don't need to get it copyrighted to say myself author and owner of that work. I have created, so I become the owner. So I just have to prove the creation. The moment I have proven my creation, I receive all the rights. So just creating a work, I become the owner and author. So here in your question, if you write a novel, then just publishing it in your name means that you are the owner of that work. But what happens that when you go to the court, suppose you have written a story, then question comes that why do we register a work if
Yeah.
just merely by creating I become the owner and author? Then what is the requirement? Why I spend money and time to register a work? It is
Yeah.
important because it gives you two main protections. First of all, whenever your work gets infringed and you have to file a case against your infringer, you need to submit in the court of law registered copy of your work, because that is a prima facie evidence. Suppose I have written a story So I need to prove through all those documents that I have written a story. But when I just submit a registered copy of my story, then prima facie I have proved that I have written. I don't have to just submitting the registered copy is sufficient. I don't have to prove any additional evidence or witness to show that I am the writer of that work. So here you will get a upper hand. That opposite party has to rebut कि नहीं इसने नहीं लिखा है मैंने लिखा है. So that person has to rebut that. Your burden of proofs ends there. So this is one of the major benefit of registering the story or registering a copyright work. Second important benefit is it gives you a kind of professionalism. People will, if they see the registered copy, they get the impression that this person is serious about his or her right, and I should not we should not indulge in the copying in that. So this creates a kind of, you can say, professional upper hand to the person who has registered the work. But major thing is that registering a copyright work is a evidence that you are the author of that work. And when you get it registered with the Copyright Office, then it becomes the proof that you are the author as well as owner of the copyright work. So this is what where the registration gives you an upper hand.
Are there any minimum payment plans or slabs, especially for the screenwriters? Because they are writing for television, they're writing for OTT, they're writing for films, or for ad films. So, is there any payment structure minimum in case of a dispute, or because most of the writers are not aware what they should charge? They produce a script, give it to the producer, and the producer. They don't know. I get a lot of calls for advice that how much should we charge a producer for a script?
Yeah. Very good question again, this. And I have something to add also here. So yes, when you say, is there any legal limit or legal minimum amount that a screenwriter should charge? Then the answer is no. There is it always depends upon the contract which you have signed with the producer, and there is no minimum amount. I have seen people coming to me who has written stories, screenplay, and dialogue, everything for just 50,000 or 1 lakh. The minimum amount like that, a small amount like that. So, Screenwriter Association, they recognize this problem. Two types of problem. One, sometimes writers don't know how much to charge. And secondly, that they want to know that, okay, fine, I need to have some minimum amount in mind. So, SWA came up with their minimum payment slab, which is there on the website of SWA, which to give an writer idea about कि चलो इतना तो तुम charge करो ही करो. It should not be in the 50,000, 60,000. You should not write in the amount like that. Now, it gave screenwriters some idea. Okay, fine, this is the minimum amount I need to charge. But this idea is of no use when your producer is denying that no, we are not going to pay you even this minimum amount, or this minimum amount is too much. We are not going to pay that. So there is no legal protection. So I was researching a lot about that, because currently copyright, the Copyright Office or government has shown their intention to amend Copyright Act. So and they have asked consultation from the people, from the writing fraternity or every person, that what changes should be brought in the act. So I regularly write a blog, attorneyforcreators.com, where I have written many articles in the benefit of the creators community in whole, not just confined to screenwriters, but all entire creative fraternity. So I have written one article recently that what changes are required to be made. And I'm in the process of writing another article about this, your exact question, that should there be any legal limit, or should there be any minimum amount defined in the law to get the writer's benefit, that this minimum amount should a writer should receive. So I read many laws, like legislation of different countries, and I found that in the country like Austria, in the country like Germany, there is the statutory limit. Like the government has the copyright law, it promises that a writer should get the equitable remuneration. equitable remuneration decided when the producer association, writer association, they sit together, they collectively bargain by taking the budget of the film, by taking the earning of the producer, by taking the budget for the stars and everything in consideration, and then they define the equitable amount that a writer should receive. So when a writer receives more than equitable amount through the contract, then it is fine. But when a writer receives less than that equitable amount, then that agreement is required to be amended, and at least that minimum amount should be paid to the writer. And that was a very good example which should be there in the welfare state like India. But I'm surprised and a bit disappointed too, because I'm not getting more and more creative community people coming ahead and putting their suggestion. If farmers can protest in the like the cold winter Delhi, then why not even writers should come up with their suggestions? So I am writing this another article, and I want the people to share it more and more, so that it should reach to the government body. They should at least think on all those possibilities, because you need to do, only then you get here. You don't get anything by just sitting in this country. So
Exactly. I
yeah,
guess, yeah. I mean, one needs to fight for your rights and to be heard.
yeah,
And if you go by the labor law, there is a stipulated minimum wages, even for the daily
yes,
wages worker. It's like there's a
yes,
minimum slab for that, and there is a minimum number of hours that they have to work for, and so
true.
on and so forth. So, if that can be deployed for those departments, or the area of the worker for the labor law, then why not for the writers? I mean,
True.
or writing is not considered to be a labor.
Hmm. True, true, true. It should be. It should be. And our country really needs it because of the huge difference in bargaining power. It's not there in the US. It's not there in UK, and we cannot compare with those countries. And sorry, in UK it's not there, but in other European countries like in Austria and Germany, I have given example. They are more developed than us, but still they have this protection. So this is very important. This is very important change which required to be made.
So nowadays we see this the advent of OTT for the web series. It has opened a lot of horizons for the writers, the new age writers. Uh, because earlier it was very limited to writing for films and for television, and OTT has given a very different dimension of writing and the writing acumen required. And a lot of people are writing for the OTT, which is going for the international. Audience basically. I mean, OTT is not limited to within the country audience, like when we have a Star Plus or a Sony and all. The audience is limited to your own country, or your film is released in your own country, but it is also released overseas, but that's very limited audience there. But when we have an OTT which is on internet, it's accessible 24/7, and it's accessible in the countries wherever the internet is there, so as to say, and especially the Google platform or the YouTube platform. So, what is the complications it has resulted or given accrued for the writers who are writing for OTT? Are there any new standards or laws being worked out, and the payment structures accordingly? Because we don't have a royalty system or a payment structure to match the international standards now, since your work is being seen outside the country also. So, how is this payment structure being planned out?
So yes, OTT has given a lot of opportunity to everyone, including writers. And due to OTT only, we have came across such a good Indian TV series, which were not there before OTT era. But the problem, yeah, for the established writers, I don't know, they are getting their due, they are getting good remuneration, maybe. But again, when it comes to newcomer or struggling writers, generally they don't directly like what OTT do. They generally commission a project. So they commission the project to the producer or the creator of the show. Creator of the show are the one who go and hire writer, director, star cast, and everyone. So when there is a problem in your structure, when there is the problem, there's always problem between the producer and writer when it comes to a fair agreement and fair terms of working. I don't think OTT has made any new change or any welcome change. Like, it might be in some cases, but in general, the problem remains the same, that writers do not get a proper or fair agreement. OTT might have like commissioned and given them the fair amount, but that sometimes does not reach to the writer, and they have to again sign the similar kind of biased or biased agreement or one-sided agreement with the producer, and their condition remains generally the same. But yes, sometimes if your show gets hit, you get recognition, and then you might improve your position, and then you may be treated fairly. I don't know, those things may happen. But yes, when it comes to contractual exploitation, it is I think there, even in the case of OTT. And you put it very well, that since the OTT viewership is very large. It gets viewership outside. It gets viewership in the entire world. There should be self-regulation also, and there should be a fair regime where the writers and the lyricists and everyone, they should also paid uh, higher. So those things are required to be seen. But right now, I see the similar problem. I see the problem where the even in the contract of web series, which is there between the producer of the show and writer, those unfair terms and conditions are there. And when you compare the payment of a superstar, and when you compare the payment of a writer, there's huge disparity. For a film or for a web series, just like established actors, they receives in crore, and the one who has created the entire path work, they don't receive the desirable payment. So yes, there is huge payment difference, and those problems are there, has not changed.
So I hope these issues are taken care of, and you do pop up these questions in your capacity with all the possible film associations. Is there a kind of a possibility, or already existing something to work out a synergy between the writers associations, or a group of writers with the producers associations, etc., to arrive at some ballpark figure and a model contract and all that we discuss?
Yes. So yes, we are looking in that direction, and we are working in that direction. We are like, first of all, we would like to create a model contract, and we want like negotiation with the producer, so association. So yes, that thing is there in the pipeline, and I'm sure that in coming time there will be welcome change in this direction. And I know there are many producers who are willing to be fair with the writers also, and they are willing to make the proper payment. So so there is no dearth of such producer or production houses too. And yes, the proper dialogue between the writers association, producers association, or individual producer, that is constantly going on, and situation has improved too. It's not that we are stuck where we were 10 years back or 20 years back.
Yes.
Because those time I was not there, but I
Yeah.
can read, like I can read the situation, I interact with the people, like you or other people in the industry who had been there in the industry for 10 to 15 years minimum, and they tell me that that time contract was not a thing. We were not even considering those documents. Everything were verbal. And yes, the agar if with agreement writer is facing this type of problem, then without agreement, so it was like completely exploitation. So but the situation has improved a lot, and no doubt SW has a great role in creating awareness and bringing the writer from there to here, and we are going forward only.
Uh, is there any permission required to make a biopic?
Okay.
If yes, then what kind of
Yeah.
permissions are required?
So again, it's a bit tricky. So see, copyright does not protect fact. Okay. So whatever my life is there in public domain, anyone can write on my life without, they don't need any permission, or I cannot sue them for the violation of copyright or something, because that is a fact present in public domain. For example, for making crown, the makers had not taken any permission from Queen Elizabeth II or something. But then there is always risk. There is a risk that person on whose life you are making something, they can sue you for the breach of privacy. They can say that, okay, fine, I don't want to come into the public light. I don't want my life to be scrutinized by the masses. So I want to remain in peace, and I don't want you. I have not given you right to publish my life again. So they can sue you for the breach of privacy. There may be a case, or there may be a case in which you can be sued for the defamation. Suppose you have shown up people in the light which they don't like. In that case, they can sue you for the defamation, or they can say that. So there are several possibilities of litigation. You do not have any creative liberty. Say you can take a defense of truth, but what has happened in the four corner of the wall, if you are showing that to the public, then they can sue you for the defamation, that it is not truth, it is not there in the public record. How do you know that this thing exactly has happened? So there are so many risks involved when you don't take a permission and go ahead with the biopic. So it's always advisable, being a lawyer, I will always advise to get right. There is a this right called life right. You need to go and ask the people that, okay, fine, I want to make a biopic on your life. I would like to make you certain, like, consideration, payment of the certain consideration. Then you can receive the exclusive right to make biopic on their life. You can, in that agreement, you can take the creative liberty that, see, for making it dramatic, or for making it more preferable among the people, I would like to make certain changes. Then you can take, they cannot sue you for the breach of privacy. You can say, I can use your real name, your real life instances and everything. They will give you the permission for that. So then it becomes very smooth. Now you do not have any sword hanging on your head for the defamation suit or the breach of privacy suit or any kind of suit. So yes, it's better to go and take life right, due permission from the people on whose life you are going to make a biopic, and then you can go ahead with the biopic.
So this is what you spoke about is about a biopic on a person who's living. But
Yeah.
what about if a person is not living? It's posthumously.
Okay, this is deceased person. So yeah, even in that case, you can. There are two ways to take. First of all, you can go to the legal heir of that deceased person, and that legal heir can give you, like, see, life is also like all the property and every rights rests among the legal heirs. Similar things happen in the case of the life right also. So when a person dies, then you can go to the legal heir of that person. You can talk to one legal heir that, okay, you can give me the right and the permission to write something on the life of that person, as well as you need to take the NOC from other family members too, and you need to make the representation on the behalf of all other family members, that tomorrow it's not that I have taken rights from you, and tomorrow certain ABC or the other legal heir comes and says, oh, no, I have not given you right, how can you do that? So the life right agreement which you draft, it should not be, people generally, I've seen people just download the template from online sites and they make that template sign. But that again creates problem, because there are so many nuances which a lawyer understands. So always go and get it drafted through a proper law, through a media and entertainment lawyer who can understand each and everything, and then there is no problem. Or suppose there is no legal heir, but there the person has created a trust in his name, so you can directly go to the trust and take the permission from that trust or rights from that trust, and then you can make the biopic. So there will be always a way to take permission. So instead of just avoiding permission, I would suggest go and take permission and then go ahead with your project.
There's always this battle between the difference between the concept, the idea, the story, then the screenplay and dialogues and lyrics. There's so many avenues for writing a script. So one a question which is often asked is, can you copyright an idea for a film?
And straightforward answer to this is no. You cannot copyright an idea. Okay. Now, how to protect an idea? Because idea is the USP. Everything is based on that simple idea. So so in copyright, you can protect just expression. You cannot protect an idea. So I have again written an article on this subject on my blog at attorneyforcreators.com, that suppose you have an idea, awesome idea for a reality show, and again you cannot protect an idea. So you should not directly go and tell any person that, okay, fine, I have this idea. First of all, you need to structure that idea in a form of expression, that what is your reality so all about, how it is going to function, define all those steps, how you are going to choose the contestant, what type of variety are you putting in that show to make it interesting, on what basis those contestants are going to be judged. All those things should be written in a very clear framework. I would again advise you, go to a lawyer, because see, a lawyer will understand that what is a protectable part and what is a non-protectable part. So idea is a non-protectable part, and have you expressed that idea in a manner that it has become protectable, she will guide you properly in that regard. Okay, then when you have this proper structure, now this is a protectable work, even if it's an idea, but you have a clothed clothed in it in a way that it has become an expression. Now, protection of an idea is better under confidentiality law, better than copyright law. So just copyright law provide a very superficial protection, but confidentiality law provides a deep protection to your idea. So before you pitch the idea to the producer, you can have a simple NDA with the producer. Again, be very cautious about signing an NDA with the production houses, because NDA is what? It is non-disclosure, that I am submitting my information, I am submitting my idea as well as its expression to you, and you are going to evaluate it only for the limited purpose that whether you want to have future relationship with me or not. It is not, I have not granted you any rights. That should be made very clear. There is no rights that has been granted to you. It's just that I have allowed you to evaluate this project so that we can work in the future. Now this has happened, so and you cannot share it with any other person. Those things should be there in the NDA, and once you have signed that NDA, then you pitch your idea and the expression to the production house, and in that way you can protect it. So you need to be a bit more cautious when it comes to like pitching your idea or protecting your idea.
So you mentioned about the confidentiality law. So is there any office or a domain or a website where the writers can go and register this, like the copyright office or SWA?
No, nothing. So yes, in SWA you cannot register your idea, but when you structure the manner I have explained, if you structure your work in a way that it just not remain an idea but becomes an expression, and then you can go and register it with SWA. But just merely registering it with SWA will not work. Whenever you pitch, you try to have a NDA with the producer or production house or platform, and if that is not possible, then at least write a detailed email in which write all the elements that whatever I'm pitching you is under confidence, and I am pitching you only to evaluate. You cannot share it with anyone without my permission. And if you want to go into the further professional relationship with me, then you have to sign an agreement with me. All those things should be, you can get it drafted by a lawyer also. Again, a media and entertainment lawyer, because they will understand the nuances of your email, because sometimes people go even lawyer, and I don't know why they don't deny, but they misguide the client. They wrote in a manner which do not protect them, and then sent to the production house. So yes, be cautious about your work.
How do you know that your work has been plagiarized, and what is the comparison? I mean, if you need to make out, I mean, between the two works and come on to a decision whether it is plagiarized or not, is there a particular yardstick or a formula to arrive at that?
Yes. So unfortunately, there is no formula, but yes, I will explain you how can you know, at least get a vague idea.
Yeah.
So, see, first of all, whenever you accuse a person that this person has plagiarized your work, then first of all, you need to prove the excess if your work is unpublished work. Suppose I have written a screenplay on my laptop, which I have not shared with anyone, and tomorrow I come to know that Mr. Bajaj has made something very similar to my work, which I have made written on my laptop. I have never emailed Mr. Bajaj anything or not even talked to him about this. Then
Yes.
I say, oh, you have plagiarized my work. You have stolen my story. How he has stolen the story if the story has not reached to me? So the first step, if the work is unpublished, when the work is published, then it is in public domain, then you don't need to prove access. But in case a work is unpublished work, then there is a requirement to prove the access. I need to prove that, okay, I had emailed Mr. Bajaj my entire story, screenplay or story, whatever, to him. Or like today we are in conversation, I have this recorded conversation in which I have explained my story to you, so that story reached to you. Then this is the first step. Like in the case of unpublished work, instead you will never ever win any battle without proving the excess. Otherwise everybody will keep accusing another person, usne mera chura liya, usne mera chura liya. So you need to have an evidence, you need to prove the excess. Okay, it's sometimes very difficult because what we do, we say we share it with our friends, and then friends share with their friend, and it gets spread, and we do not know the chain, how the work reached to that person. So again, the onus will come to us only. We need to be very cautious when we are sharing with anybody. We should not share with the person on whom we cannot rely, or who can spread the work in the entire industry. Or sometimes I have seen the writers, they spread their work, like they send to everyone XYZ, and not even through email, sometimes hard copy, or sometimes they just verbally explain. Those things should be, I'd highly discourage all those activities, because then nobody is going to save you. So proving an access is the first point. Now similarity, see, just similarities are not sufficient. Just if a work is similar to another work, you cannot make it, you cannot say that work is plagiarized. I can give you an example. Suppose I have made a film on which a blind girl who is who has defeated all the odds, and she has conquered Mount Everest. This is my story. Okay, I came to know that another filmmaker has made the similar film in which there is a blind girl. She has defeated all the odds and she has conquered the Mount Everest. So, merely looking at this superficial similarity, we cannot say there is a plagiarism. In my story, when I look in detail, my story was set in a village area where this girl in a very like in a 15, 16 years age, she gets married to a older man who is a drunk, who used to beat her, and then he dies, then all the responsibility comes on her shoulder. She struggles and then she gets some training through an NGO, and then she conquers the Everest. Suppose this is my story, and their story is a girl. She is from a very modern family where the father has supported her a lot. That a person with vision can do the similar thing which you can do the similar thing as the person of vision. Then he trains her, he becomes her coach, and then she conquers the Mount Everest. So see the difference. So this is the difference in the expression. When I told you the basic premise, so everybody will say, oh, this is the copy, the work has been copied. But no, see the how it has been expressed, the character, the plot, the subplot, the struggle in life, the conflict, all these things are required to be compared, and then only you can conclude that it is a case of plagiarism. And there's no straight jacket formula. The court has given some test, like the passerby visitors test, who is a common visitor when watch film A and film B and feels that okay, everything has been copied in film A from film B, then this can be example. But no, it requires a analysis, bit by bit analysis, and then only you can say whether it was plagiarized or not.
So, how expensive is the registration of a script or for copywriting a work by the writer?
Okay, so I don't think it's much expensive. In SWA, it's I think very cheap. And when you talk about copyright office, even I think 500 rupees is the fee to register your work there
That's
in
very
the
nominal.
copyright office.
That's very
That's
nominal.
very normal. Yeah, and but in copyright office, it takes you 8 to 10 months to get your work
Oh,
registered. So yes, that is a time-taking process, and it includes multiple steps. So yeah, that is a difference. And here, when you in SWA, you get the instant registration. So this is also difference.
What is we hear this common term in the international arena, which is poor man's copyright. What is this term used for? What does it mean? I mean, does it hold any ground in court?
Oh no! In here, law is very like so. Law is common. Law is the same for a billionaire as well as a poor man, although the enforcement may different. So, for a poor man, it's tough to pay the attorney fee. A poor man, it's tough to like hire an attorney or fight a litigation. So yes, when then there is dissimilarity between both, but law keeps the equal values for everyone.
So that sparks a question that if a writer like a poor man and he cannot afford the attorney fee and the court fees, etc., then how? What does he resort to? How can he fight his battle? Are there avenues open for him?
Yeah, so of course, for India, for any, you forget the writer, even the common man from the very weaker background, they are fighting litigation and they have to pay the huge cost of litigation and they have to pay all those struggle and everything. So yes, that happens. But when you come to especially about the writer, so Screenwriter Association has came into the rescue out of it because they have their legal aid society, they legal aid committee. So if you have a very strong case in which you if your case has merit and if you want to fight against the production house, then they provide you the legal aid in which they share your cost 50-50. Like suppose your cost is 4 lakh, then 2 lakh will be paid by the association and 2 lakh will be paid by you. So it's a kind of the assistance, and then maximum they help you till 2.5 lakh. So right now the amount is limited to 2.5 lakh maximum with the SWA. Suppose if you incur cost of 6 lakh, then they will pay you the 2.5 lakh till 2.5 lakh. So so this is a kind of help, and they are going to expand it in near future. So yes, so legal aid only help, I can say, when it comes to poor man and litigation.
Like you said, if that's a very good step, what you're mentioning, that if SWA is planning or is implementing this support to the writers for fighting their case in court, the sharing of the cost. Now, is the sharing of the cost is to be paid in advance by the writer? Because if the writer does not have the money, because see, if the foremost, if he had the money, he would have gone on his own. He wouldn't need a SWA support. Uh, the fact that he's taking support from his association means that he does not have the money. So, in this case, how does the things progress or process?
See, when you are the association, when you are a public body, you need to take consider everything because that is your not your own money. That is the money of all your writers, and they are the
Yes.
custodian of that money. So they cannot. They keep. Each penny is very valuable. When it comes from a private individual, then I am very generous. I can pay whatever I want because that is my money. But when it is a
Yes.
public money, then there is the requirement of proper legal framework. So I am the one who has drafted assisted in the drafting of their legal aid policy. And when you are going to the court, then of course an SWA is promising to share your burden. So in that case, you need to have certain money in your pocket, and you have to have a certain willingness in your mind that okay, fine, I am going ahead with this litigation, I am going to fight. And willingness comes from the investment if you go practically. So yes, we will like SWA will share your fee, but again you have to start it. When you start it, we will back it. So this is currently the SWA's ambition in this regard. And this is again the experiment. It is going to evolve from time to time, considering on the case, proper putting all the proper study in all the cases in which we have help. So currently, you need to invest. The first half will be paid by you. The second half will be paid by SWA. So this is how they
All
work.
right. So the basic message here to the writers is that you have to have money in your pocket to start your battle.
At least, without which legal battle is impossible. You have to have something in your pocket. to
Yes.
fight. Or otherwise, in mediation, if you are lucky enough and if your producer is cooperative enough, then in mediation sometimes you win, you receive money if you have a
Yeah.
very good contract in your favor. So again and again, I focus more on contract will help you. Recently we have helped writer in mediation, and writer has received a very good amount of money because he had contract. Even with contract, producer has refused payment. So yes.
Um, what are the taxes payable by the writers? Like we have, engineer has to pay a certain kind of a tax, or a doctor has to pay a certain kind of a tax, and so on, like that. So, is there any
Yeah, yeah.
particular tax slab specially created for the writers?
No. So a tax attorney will be better to like give you to the point and detailed answer. But I can give you a like brief answer to this question that
Yeah.
there's no, in my knowledge, there is no any special tax that is entirely designed for the writer. I don't think there is any such. But yeah, like TDS, if you are a writer, your TDS gets deducted in your service like producers, and sometimes GST is there. So these are the common tax, and then you have to pay the income tax if you are rich enough. So those things are like, those are the slabs and those are the common tax. There's no special tax only designed for the writer, in my knowledge.
Is there any system for the royalties? Because most of the contracts that we see has this clause where the producer has mentioned a clause to the writer that it happens with the actors also and other departments that you waive off your rights for royalties. It's a one-time payment. Is that acceptable? Is that legal? Is it valid in court? And if not, then is there any structure for the royalties to judge or to assess or calculate the amount of royalties? Like we have the IPRS,
Mm,
which does for the music and
yeah,
all. So, is
yeah.
there any body or a system for the writers?
Royalty for screenwriters is a very painful word because and very illusionist word in which the writer, they just listen but they never received. And the problem is that yes, 2012 amendment says that for you have statutory right to receive royalty when it comes to musical work and when it's come to literary work. Okay, now the and only copyright society is entitled to collect royalty on your behalf. So what has happened? To collect royalty, writers is required to form their copyright society. The writer tried to form their copyright society, but then the question came that screenwriting or a script is a dramatic work. It is not a literary work, and a dramatic work author does not have right to receive royalty, statutory right to receive royalty. And I don't know, there's no explanation to make differentiation between the literary work or musical work and dramatic work. I don't know why, if a lyricist should receive the royalty, then why a screenwriter or why a scriptwriter should not receive the royalty. So that tussle is going on between the screenwriters body as well as the government body, and the application is before the bureaucracy, and it is waiting the approval. Once that approval it receives, then at least the story writer or at least the literary work like the dialogue writers, those will start getting royalty. But again, for the dramatic work, for the script writer, the act is required to be amended, and in the section 19, together with the work, musical work, literary work, there is requirement of addition of the dramatic work, that all of them should have the right, statutory right to receive royalty, and that is non-waivable. Those rights cannot be waived through contract, because when you make it a waivable right, then they are going to make you sign an agreement in which you are going to waive all the rights. So there is no point of having those rights in the law book itself. So yes, again, in the my last article, I had written it in detail that how the law is required to be changed, why the dramatic work should be added there, and why everybody should receive the royalty, why the copyright copyright society for writers is required to be formed, and that will form only when the bureaucracy will give them approval. So how that approval is important, and how the writers should receive their much needed due, like, yeah.
Like there are rights which are fundamental rights and which cannot be waived off under by even the Supreme Court declaration is there, and the jurisdiction which clearly mentions that you have no right to waive off your rights.
Yeah.
That clause is there. So if that clause is there, then how come these clauses are put in a contract and accepted by the writers, and also honored by the writers associations across the country?
No. So see, all the rights are not non-waivable rights. Okay?
Okay.
There are two types of rights. One is alienable right, which you can alienate. Suppose your rights on your property, my right on my house, I can alienate it. It means I can sell it, or I can waive it. I can renounce myself that I don't want any rights. Suppose I can tell my father that in all your property I am renouncing all my rights. I don't have any rights on your property. I can do that. Okay, so that is something which is called alienable rights, which is called waivable rights. And something is non-alienable right, like right to receive a royalty by literary work author is an inalienable right. So a literary work author cannot or musical work author cannot alienate the right to receive royalty. So
Okay.
writers association or anybody, these contract is void per se, but only right to receive royalty, when you come to the copyright law, only right to receive royalty is non-alienable right. All other rights are alienable right, which is a very bad thing, because moral rights, author, what is moral right? Moral right is the right to call the father or the creator of your work, and
Yes.
right to have dignity in your work. Like today, I give you the example of that Mirzapur season 2, in which the Dabba book author, he had made the objection because a character in that TV series was reading that book, and a pornographic content was playing in the backside. So he said that that is not written in my book. My book is not the pornographic content, and this is like you have violated my moral right in that sense, my right to have dignity in my work. So this is the basic right which a writer should receive, and in India that is even waivable. We have seen in many contracts in which writer is waiving unconditionally, irrevocably all the moral rights in the work. So
Yeah.
that is permissible, because law does not say that it is not alienable. Another right which I have always advocated that it should make non-waivable is, suppose section 19.4, which says that if you have assigned a work in the favor of certain producer, and if that producer does not exercise that work within a year, then right comes back to you. Even that rights get waived. So no writer gets the benefit of that right. The right in the through contract, it gets waived, because law permits all those waiver. So we need to make change in law per se, which say all these rights are not waivable. And then, of course, because what can SWA do? It is not above law, right? If the law allows the waiver, we can just say our members that please don't waive that. Or I am, as a lawyer, I can just suggest my client don't waive those rights. But then producers say, okay, Tata, we are not going to work with you if you don't sign this agreement or if you don't waive those rights. So I think that welfare measures should come through legislation.
There are various kind of contracts and agreements floating in the industry, and which the writers are often presented with, and their headings are, absolutely gibberish to the writers as a layman from the legal point of view. Like terms like you have an option of a purchase agreement, you have a collaboration agreement, you have a representation agreement, you have a submission release form, or a shopping agreement, uh,
Yeah.
and a difference between like a hire and purchase agreement. So can we throw a light on these aspects or type of contracts and what they mean and what they stand for?
Yeah. So yeah, as you rightly said, there's so many types of agreement. So collaboration, I'm starting from the collaboration agreement. Collaboration agreement is between, like, suppose you want to write with me, like both of us want to write together the certain script. So we need to have a collaboration agreement, which may call the co-writer agreement also sometimes, that we in which we write all the terms and condition of our engagement, that I'm going to dedicate my time on these parts. This should be the terms and condition. I should receive the first credit, you should receive the second credit. We cannot pitch without keeping ourselves in loop. We need to like pitch together to certain producer, and if we get certain producer on board, then we need to have a tripartite agreement with that producer. IP will be divided 50-50% between you and me. All those terms and conditions should be there. That is called co-writer agreement, and sometimes it's called collaborator agreement. And collaborator agreement can be anything. Suppose you want to collaborate on any project and you want to sign a person to help you in that project, that can be collaborator agreement. You talk about another, what was the next agreement you talked?
A representation agreement.
Representation agreement is between the client and a lawyer. I have not seen in India, there's no generally there's no culture of representation agreement, but actually representation agreement is between between a client and the attorney. So yes, and then you talked about the submission release
Yeah,
form.
yeah.
This is one of the most exploitative kind of agreement, or you cannot say it agreement. It is a document which should be renamed as release or submit all your rights for nothing agreement, because in this yeah, in that there are those are the languages, like you are submitting all the rights to us, you have no claim. If we make even the identical work, you cannot go to the court. You have given us all the rights, you cannot do anything, you just go and die. These type of submission release form, I had a huge issues, and I have talked a lots of I wrote individual emails to all those production houses with in the SWA. We discussed it, and I individually wrote to each and every production houses that you cannot have this illegal kind of agreement, that you cannot stop a person from going to a court, which is their last resort. At least you cannot do that. But unfortunately, a very few of them replied to my email too, and unfortunately, those kind of release form is there in the industry. And I really appeal all the writers that at least they should have a heated debate with the production houses, that how can you make us sign the agreement like this? You cannot make us sign the agreement like this. So this is what the release form is. Basically, release form is just to production house wants to protect their interest, that tomorrow if they make something similar, then the writer cannot sue. But okay, I understand the case of similarity. If something generic similar, as I have explained in my example of that
Yeah,
blind girl, if the
yeah,
similarity is like that only, and then
yeah,
if someone sues you, then it is a frivolous suit. That suit does not get a ground. But if you make something identical, if you make something substantially similar, then how can you think that I would just watch and wow, my work get infringed, and I cannot take action against you?
yeah.
So, and those languages in those release form, then those are pathetic, and people should have some conscience to avoid such languages. And even in-house lawyers, I just say that they need to think a bit before they draft that. So that is what the release form. I became. My battery is low. Can I just
Yeah, you can
I'm
put it on a charger. Yes,
charging.
you can
Yeah.
put it on a charge. Yeah. So that's a very interesting conversation going ahead with Ms. Anamika Jha. I'm glad and happy that she's throwing light on all the aspects that we have been discussing about the legal issues faced by the screenwriters in India, especially. And she has put a lot of detailed answers to our questions, which is I would say I'm very satisfied to have an attorney like her amongst us, and it's uh, it's really great that you are talking so much in detail about these points, Anamika. And you are enlightening all our viewers, especially the writers, who are actually living in dark and are not aware of their own rights. And we do not have any platform where the writers can be made aware of their rights. It's they have to go through so much of knowing the people and climbing the ladder, getting into the association or getting the right attorney or at least the guidance, I'm sure at least this conversation can spark off some awareness in that direction and can set the ball rolling for what you are trying to achieve to help the writers and the writers' issues and formulate a system. So, coming back to our original question, where we were talking about the submission release forms, my limited knowledge says that the Supreme Court has a clear verdict that no contract can be one-sided. If any contract which has been signed by any party, which is totally one-sided, uh, even if he has signed the contract, then the contract will be termed as null and void in Supreme Court. Is that true?
See, if an agreement has been signed under misrepresentation of fact, or if someone has taken undue advantage of you, suppose I being your lawyer just misguide you and make you sign certain document and which you are later able to prove, in all those cases, yes, the agreement is null and void. But generally, in the case of the commercial transaction, where it is presumed that writer and the producer, they are equal entity, they are sitting across the table and signing some contract. So legally, it does not. It like it's very tough to prove that okay, I have signed under certain misrepresentation, or I have signed because I was compelled to sign. There's always question that okay, fine, if you don't like, then why you have signed? So yes, there are court guidelines, there are some guidelines that okay, in certain case the agreement is null and void, but this cannot be taken as a fact, or this cannot be taken as a sacrosanct statement that if you sign a one-sided agreement, then that agreement is null and void. No, that agreement is enforceable, and it's very tough to prove that agreement null and void. It's very tough to prove that to say that this agreement is not enforceable. It's very tough, and you never should like keep it in your mind that okay, it's fine, I am signing null and void agreement, one-sided agreement is not going to enforce. They are going to enforce to you on you, and it's very tough to prove that agreement is enforceable. So I will always say that don't sign an agreement which is one-sided. Don't sign an agreement which is completely in the favor of one party. Always try to negotiate, and if they are not ready to negotiate, then it's that project is not worth it, because in future you are going to suffer so many problems. And now coming about the awareness platform, then I would suggest you regularly visit SWA website. I write their corner, legal corner too, where I make you aware of all your rights, and that is directly linked to my. I have given SWA the access to my blog too. So whatever article I write on my personal blog related to writer, that gets published on the SWA website too. So when
Okay.
you regularly follow these two websites, SWA website and attorneyforcreators.com, then every time you get something new. And I try to write in a very layman language, not in a legal language, because
So
I
that it
know
is relatable and it connects.
yeah, I'm not going to teach or tell lawyers. My fellow lawyers, they know themselves well. I don't have to educate them. Or neither I am
Yes.
writing currently a legal journal. When I write a legal journal, when it gets published to all the for the lawyers, then I write, of course, in a technical term and in a legal language. But I always have believed in a simple language. Whenever I draft a contract, I try to make it so simple that even like a person without any legal background can read that, can understand that, because they are the one who are entering into the agreement. Lawyers are not going to enter into the agreement. So simple language agreement is my prime objective. I don't use those legal jargons because those are not important. Both the parties should understand. That should be the aim of any legal drafting, and I promote that.
What is a shopping agreement?
Shopping agreement, yeah, it's very interesting agreement, again not existing in India, and I would not suggest even Indian author to sign that agreement, because again there is a danger of exploitation. So what is a shopping agreement is that in through that agreement, producer or any you can say, here I'm just focusing on producer and writer, therefore the producer takes permission from you that, okay, Mr. Writer, give me the permission to pitch it to the different platform, your work. And once this project gets greenlit, then we will have a formal agreement, and then we move ahead in the project. In that case, you are not paid any money for pitching that, for giving them right to pitch the agreement. You just believe that, okay, tomorrow the agreement will get greenlit, the project will get greenlit, and then I will earn something. I would suggest you rather to sign an option agreement. Option agreement is a better substitute of this shopping agreement. In option agreement, you will receive money. Suppose I have a very good concept, or I have a very good story. You as a producer like that story, then you say ki, okay, Anamika, the story is fantastic, I'm going to pitch it to Netflix, Amazon, etc. Then I can say, okay, Mr. Bajaj, you can make certain payment to me. Like suppose you make me the payment of suppose 1 lakh rupees right now, then I will give you the pitching right. You can go and pitch for a certain period of time, suppose 6 months or 1 year. If in that duration you bring certain OTT or certain platform on board, then we can have a assignment agreement in which I can adjust this option price which you have paid me right now, and then we can work together. And if suppose you are not able to bring any platform or any producer on board or any commissioning platform on board, then after 1 year your right will expire, and this 1 lakh will be my opportunity cost. So this is a better way through which you can get certain amount for in that waiting period. So instead of shopping agreement, go for option agreement.
So, what is a hire agreement? I mean, there's a purchase agreement and a hire agreement, and what is the
Okay.
difference between the two?
Okay. So again, this is like not Indian terms. In India, there are two types of agreement. One is work for hire agreement. Another is not purchase agreement, but copyright assignment agreement. So copyright assignment agreement is the agreement. Suppose you have developed your work, and now you are going to assign it to the producer or assign it to any other person receiving money. So you will remain the author of the work, and now you are assigning all your rights to in the favor of another person and receive the compensation and credit for the same. While work for hire agreement is that, suppose I am a professional writer, producer has a very good story, or producer has a very good concept. Now that producer approaches to the writer and says that, okay, I'm hiring you to write this as a professional. You will write as per my instruction, and I shall pay you the money in accordance with that. But all the rights will belong to me, and you shall only get the money and credit. So that is work for hire agreement. In that case, the producer remains the owner. The author does not get any ownership on the work.
Uh, Thank you, Namika. I have exhausted the list of my questions to you. If there are any questions left which you think you would like to put light on, please go ahead.
Yeah, so I would just say that in the industry or in any profession, always spend your time, money, investment, everything on the pre entering into the relation. Before you enter into the relation, have a proper agreement in place. And I'm not just talking about the writers. I'm talking about, you may be a director, you may be a actor, you may be even the producer, even sometimes small producer or independent producer. They get lost in all the project because they don't have the proper documentation in place. So before you start any work, have a proper documentation in place, have an agreement, and have a fair agreement, because agreement is, there's no requirement of keeping someone in the disadvantageous position, keeping yourself in entirely advantageous position. There can be a balance, and that balance things work better, because then there is a very less chance of conflict. So have a balanced document in place, and then work. There's very few litigation, and then the work culture as well as the manner in which our industry is growing, that will grow and develop. And secondly, I would say that everybody should try to read, be aware, your make yourself aware with the legality. Here I want to give an example. Recently I watched a show, everybody has watched that scam, the scam Harshad Mehta case. in that there is a scene in which his brother, Harshit Mehta's brother, he is writing a legal book. तो then Harshit Mehta asked him, तो क्या धंधे छोड़ के अब वकील बनना है क्या? He just asked, and he says
Yeah.
कि धंधा करने के लिए वकील बन रहा हूँ. Means you need to know law to be in your profession. So try to
Yes.
read. You don't have to become a lawyer because that is my job, but at least try to make yourself updated with the legality. And for that, there are several legal blogs, and I would say you need to. Why you should have a look on my blog too, because I write in a very simplistic manner, the most simplistic manner that can be possible. Follow SWA blog, and then if you are SWA member, then I'm in your service anytime. Or even if you are any creative person, you can reach to me, like director or independent film producer, anyone. So yeah, so the more we cooperate, the more we grow.
Thank you, Anamika, for a wonderful session and throwing so much of light on so many aspects of the writing, screenwriting, and also for the publication. It's amazing the kind of patience you have shown towards me. I'm really sorry to have pestered you for this session for so long,
I
and
thoroughly enjoyed.
and I hope that this is some a session which is going to benefit our fraternity of writers. And I sincerely suggest and request all my writer friends to look for guidance and approach you for any sort of a guidance in times of their difficulties and legal issues. And you are
Definitely.
working with the SWA also, and you're doing a fabulous, fantastic job there.
You.
I really wish you and SWA all the way success, and hope many more legal issues or issues which have not been touched are resolved very soon with the new laws coming into enforcement. So on this note,
Yes.
we'll wrap this session, Anamika. Thank you once
Thank
again
you.
for being with Lifft India and enlightening us. Thank you.
Yeah, it has been always a great pleasure for me. Thank you so much.
Thank you.